Hi everyone. So today I will be talking about how a US citizen child can file for their parent even if the parent overstayed a visa. Okay, so if you are a US citizen child and you want to file for your parent, or you know someone that's in this situation, stick around and I'll tell you not only if you can file for the parent, how, and the things you need to consider before you file. That's all we're going to be talking about today in this video. And let me start by introducing myself. I am Lillian Chukura with Lilly Legal. We help individuals and families that want to immigrate to the US understand how to get a green card and citizenship in the United States. Okay, and I'm going to just jump right in. I was watching a video called Petitioning for a Parent, Procedures and Consideration by Darian Immigration Law, right here on YouTube. And in watching the video, I realized there's a piece missing, right? And I wanted to cover that with you all, which is if a parent has already overstayed their visa. So they came to the US with either a B2, B1 visa, a student visa, some form of visa that allows them to stay in the US temporarily, but then they decided to stay and overstay that visa. Can you now, as a US citizen child, file for them? So I wanted to get into that because it wasn't really covered in that video. So the first thing we need to cover is which US citizen children can file for their parents, right? So sometimes people think that once you have a child that's a US citizen, you automatically get a green card. No, 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 no. So the child must be 21 before they can file for the parent. So I've had people come to me and their child is 18 and they want to know if there's any path for their child to file for them to get a green card. Well, you just have to wait for your child to turn 21. So on their 21st birthday, a U.S. citizen child can now file for their parent, not a day before, not a week before, but on the actual day of their birth, on their 21st birthday, they can then go ahead and file for their parent. All right. So that's the first thing I wanted to cover. Now, can a U.S. citizen child that's over 21 file for a parent that has overstayed their visa? And the short answer to that is yes. Right? So a U.S. citizen child can file for a parent even though the parent overstayed their visa. That is written in the laws because, right, the reason that a U.S. citizen child can do this is because the parent is considered an immediate relative. Okay, immediate relatives of U.S. citizens get this special provision where if they overstay a visa, it is waived because they are immediate relatives of U.S. citizens, right? So in this situation, even though the parent came with a visa and overstayed, it is okay. It is perfectly fine because the child is 21 years old and the parent is now considered an immediate relative of a U.S. citizen. And therefore, their overstay is waived. Okay? Their overstay is waived. Now, the question next is, how does the overstay affect the process of the child filing for the parent? Now, the things to keep in mind and consider before you file is, was there any misrepresentation when getting the visa? Right? Is there anything in the visa process when they came to the U.S. initially that could affect them being able to get a green card? So I'll give you an example. Let's say the parent came on a B2 visa, a visiting visa, right? And they, in their application, indicated that they were coming for a conference, but never actually went to the conference or lied about the conference altogether. U.S. immigration, when you go to file for the green card, could bring that issue up and use that as a reason to deny the application because they lied to get the initial visa. Okay. In those situations, you can apply for a waiver if the parent has a U.S. citizen or permanent resident parent or a U.S. citizen or permanent resident spouse. Okay. So in those two situations, if there was some form of misrepresentation, you can apply for a waiver. But something to keep in mind is sometimes the things we think is misrepresentation, the things that you may think is misrepresentation may not be misrepresentation. Okay, it may be things that can be explained, that shows that your parent was not willful in the action, they did not mean to misrepresent the information, or that the misrepresented information would not have made a difference at all in them getting the visa. If that's the situation, then you wouldn't need a waiver. You can go ahead and apply with the knowledge that the officer could bring that up and you have a defense, right? So it's always good before you start the process that you think about those things. Think about if there's anything in the visa acquisition process that your parent went through when they first came to the U.S. that could come up now before you start the process, because you want to make sure you have either a defense or you have a waiver ready to go. Okay? So that is the thing to keep in mind. As far as the procedure is just like any filing for a parent that has a visa in and out of the U.S., right? So you start with an I-130 and the green card application, which is the I-485. Because your parent is in the U.S., they overstayed their visa, they should not leave the U.S. while the visa is being processed, while the green card application is being processed, okay? So when you go to file for them, you're doing an I-130 and I-485. I typically suggest also including a work authorization and a travel permit. Why do I suggest that? Because the work authorization makes it possible, once it's approved, your parent can now get a social security number. They can get a license, they can work, right? While the green card is still being processed. So that's something to keep in mind, right? So even though you're waiting for the green card to be processed, most of the time the work authorization is processed faster, so they can get a social security number, they can get IDs, they can get a license, they can basically start a life in the US now that they have those documentation. I suggest the travel permit because sometimes your parent wants to travel. They've been in the U.S. Depending on how long they have overstayed. I've had people that have overstayed for 13 years and finally their child is 21 and can file for them, and they, one of the first things they talk to me about is, I would like to go back home and see my family. And the way to do that while the green card is being processed is with the travel permit. So the travel permit, once approved, allows your parent to travel outside of the U.S. and be able to come back without abandoning their green card application and without triggering any bars. Okay, so let me explain what that means. When you overstay your visa by 6 months, right? You stay here 6 months and 1 day, right? Past your authorization to stay in the U.S. If you leave the U.S. at that point, you trigger a 3-year bar, which means for 3 years, you cannot get a visa to the U.S., whether your child is filing for you or not, unless you qualify for a waiver. If you stay in the U.S. A year and a day, you trigger a 10-year bar if you leave the U.S., right? That means you cannot get a visa for 10 years unless you qualify for a waiver. Now, for your parent that overstayed, if they travel with a travel permit, those bars do not apply. they can travel outside of the US, right? They can travel outside of the US and come back in and not have to worry about the 10-year bar, the 3-year bar. The bars do not apply. Okay, so that's why I typically suggest also doing the travel permit, because sometimes things come up. I've had situations where people have, their parents or grandparents have severe health issues and they need to travel immediately to see them. And if we had a travel permit pending, we can ask for an emergency travel document based on the fact that there's a family member that is sick, right? But without something pending, you can ask for the emergency travel document. And if you do not have a travel permit pending at all, your parent has to stay in the U.S. until they get the green card, the actual card in their hand, before they can then travel outside of the U.S. So those are things to keep in mind as you're going through this process and figuring out which forms to file for. Now, I suggest, so what I typically do with my clients, as always, this is not legal advice. You should be talking to an immigration lawyer. At the end of this video, I'll tell you how you can do that with me. But when you're filling out these forms, when you're applying for these things, I do not just file an I-130 for a client that where their parent has overstayed, right? If the parent has overstayed, I do the I-130 and the green card application at the same time, because that provides some protection for the parent. And I make sure to do the work authorization and travel permit because if you do it at the same time as the green card application, there is no additional fee. Right? There's no additional fee. It's not costing you more to include the work authorization and the travel permit. So you might as well do it. Okay? So let's recap real quick, right? 1, U.S. citizen child can file for a parent that overstayed as long as the U.S. citizen child is 21 years old or older. Okay? The overstay does not affect the process because the parent is now an immediate relative of a U.S. citizen and the overstay is waived. The parent cannot leave the U.S. while the process is going on unless they have an approved travel permit. So you should be filing a travel permit and a work authorization at the same time so that you are protecting your parent and giving them the option to travel if that becomes necessary. Okay? And keep in mind that if there's any misrepresentation or any things while they were getting the visa that could affect their green card application, that you are discussing that with the attorney ahead of time, because there may be things that you think are misrepresentation that actually would not have affected whether your parent got the visa or not, which makes it not really misrepresentation based on the way the law is written, right? Or if it is misrepresentation, we can discuss whether your parent qualifies for a waiver, or if there's some, legal maneuvers that we can do to make sure that they end up qualifying for a waiver. All right? So if you want me, I didn't talk about this in this video, but there are situations where parents come in without a visa, without authorization. If you want me to talk about that, that's not the topic for today. But if you do want me to talk about how a U.S. citizen child can file for a parent that entered the U.S. without authorization, please just let me know in the comments, and I will go ahead and make that video for you all. As always, remember to subscribe and turn on your notifications if you are interested in learning and understanding how to get green cards and citizenship in the U.S. for yourself or for a family member, this is the space for you. This is the place for you. So go ahead, subscribe, turn on your notifications. If you like this video, if you found this video helpful, go ahead and hit the like button and share this video with your sphere, your community, so that this message gets out to people. And I told you before, there's a way for you to speak with me about your particular situation, and that is by scheduling a consultation with me. You can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. The reason I make that available is that sometimes you get all this information from my channel and you want to know if you specifically qualify. Like I said, this is not legal advice. This is information that I'm giving out here. But if you want to know if you specifically or if your family member could qualify, go ahead, go to my website, call my office, schedule that consultation so that I can really talk to you, get more information about yourself, your family member, and figure out what visa, what green card options are available to you, and we can work together to make it happen. All right. So once again, I am Lillian Chukura. I am the owner of Lilly Legal, where we do immigration law and we do it well. Bye.